July 21st, 2021 is $5,849.21, and the amount due if paid on July 22nd, 2021 is in the amount of $5,849.95. And I will also note that this schedule of arrears also gives Mr. Counsel credit for the additional payment that Mr. Counsel noted and attached to the documents that he filed on August 10th, 2021 for the July 6th, 2021 payment that he made in the amount of $550. So Mr. Page also gave you credit for that. But this schedule of arrears does not include the payment that Mr. Counsel claims that he made on July 28th, 2021. So the cutoff of this schedule is July 21st, 2021, and so it is accurate as of that date, and there is no calculation of penalties after January 30 of 2020. So this is the accurate schedule of child support arrears. And that amount of well, those three amounts that I stated, the principal, the interest, and the penalty as of July 21st, 2021. So, the amount reduced to judgment shall be $5,849.21, and that's collectible by all lawful means. And then modifying the child support retroactively to August 2018. Mr. Page, you asked the court to make the amount. You said that we should use the numbers that you provided in the additional documents that you filed on regarding the cure relief documents, correct?
Yes.
But what about using the documents that you provided as Exhibit U in the trial from the State of Washington Department of Social and Health Services Division of Child Support?
I suppose Your Honor has discretion in that regard. The cure relief numbers speak for themselves. It's basically frowned upon the court by Mr. Counsel to so willfully misrepresent himself, and in order to enforce compliance with litigants, you're free to do what you need to do to ensure that compliance happens in the future. And it's a vague answer, but it's not the first time we've seen something like this. It's not the last time. We'd like to see less of it. And if you can put in orders that are going to, one, comport with what the record indicates, if he's making $102,000 in a 6-month period, he should pay child support based upon what he's actually earning, rather than spending all his time and effort trying to avoid his duty to support his child.
Well, what I didn't understand is, I'll let you speak, Mr. Counsel. Give me 1 second. I did not understand what in the State of Washington Department of Social and Health Services, where it shows the income, it says 2018/2, 8,500. I don't know what that /2 means, or the /3.
It's for the second quarter. He made $8,500 in a quarter, which would be
quarter. Okay. Well, I don't know what the average of this is. Then I haven't figured that out. Mr. Counsel, I'll let you speak.
Yeah, Your Honor, thank you. Going back to the 509 or 529,
Yes.
again, I would have gladly taken care of that. However, I submitted the Talkie Parents conversation logs, all the evidence of me asking repetitively, how is Gavin doing in school? Can I have a copy of his grades? I have tried thousands of times. It's all there, Your Honor, and I got nothing back.
Ms. Norcutt, can you tilt your camera down so we can see you, see what you're doing?
So I have, and all due respect, Your Honor, from my point of view, he wasn't even in college.
Okay, Mr. Counsel, we've
So
already
that was
Mr. Counsel, we've already determined we're not even gonna adjudicate that. That wasn't on the table. I thought that it was, but Mr. Page is stating that isn't even before the court right now.
He's only okay, I'm sorry, I don't understand.
Yeah, he's only talking about the payment of child support for Gavin. That's a statutory requirement through the time that he was in high school. So
okay, Your Honor,
through through June of 2019. From October 1st of 2018 through June of 2019. So he's only claiming that you owed $900 for those months for child support for Gavin.
okay, Your Honor, I understand now. However, if you go back to why we're even here, when Mrs. Norcutt was granted the relocation, okay, and all of this was laid out, she took my children in I had no idea where they were at for 8 months. So I couldn't even talk to them. I had no idea. I got no response. I didn't even know where to send money to if I had it.
Mr. Counsel,
So
Mr. Counsel, none of that is before the court right now. We're just trying to figure out.
But it is.
We're trying.
But it is, Your Honor.
No, it's not. It's not.
Your Honor, I couldn't even know where they were. She took off. The district court said, you can relocate. She dumped her boyfriend and took off. I had no idea where she was. I couldn't contact her. I didn't know where to send money to. So it does. It is part of it.
Oh, thank you, Mr. Counsel. I know it's important to you.
And
it's not one of the issues that we focused on that was before the court. Everything you're arguing now has to do with co-parenting and custody.
Okay.
And those were expressly.
Well, if I had no idea where to send money to, how am I going to be held responsible for that if I can't even contact them? I was denied all parenting rights for the whole time being. That's why I filed all these. That's why I filed all the documents in January with Jason Amy. So how am I supposed to be responsible for all of that stuff when another party used them as a weapon?
Your arguments. Your arguments are not persuasive to the court regarding the issues that are pending before the court.
Well, if you want to go back to child support, all the way back to 2018, it does, because I didn't even know where they were.
So the court is granting the motion with regarding the request to increase the child support retroactively to August 2018. But we have to give Mr. Counsel credit for the monies that he's already paid. And I don't know the amount that we are imputing to him because he didn't file an accurate financial disclosure form. So I need a solution there, Mr. Page. I need you to provide me with the amount that you are requesting that the court impute, or the amount that we're going to modify retroactively, and then be sure to give Mr. Counsel credit for the monies that he has paid. And I believe that it is appropriate to award attorney's fees in this case pursuant to 18.010 as the prevailing party. And I do want to make sure that I make a finding that Mr. Norcutt was not credible in much of his testimony. Throughout my notes here during the evidentiary hearing, when Mr. Page would ask questions, simple questions that Mr. Page would have or should have known the answer to, he was a bit obstructive at times and stated that he didn't know or he didn't remember, he doesn't recall. And some of these were simple questions that he definitely should have had knowledge of. Let's see, let me give you an example.
Please.
Oh, another, while I'm looking for that, oh, here we go. Mr. Page asked him on the evidentiary day 4 on June 16, 2021, has Mom made a formal request that Dad pay the 520 toward the 529 educational plan? And Mr. Counsel says he doesn't recall. Another question: when you entered into this order, was Gavin still in high school? The answer: I don't recall.
I never got an answer from the other party.
You're interrupting, sir. September 2018. Did you notify the court that you had an increase in your income? I don't recall. So much of his his answers were evasive, and therefore I found him to be not credible. And I did find Mom to be more credible, and well, actually I just found her to be credible. And much of her evidence, her testimonial evidence, was supported by documentary evidence. The court found excuses from Mr. Counsel. Also, Mr. Page argued that Dad should be subjected to a drug rehab program. I'm not going to go that far because Mr. Page argued that Mr. Counsel had failed 2 drug tests during the pendency of this case, but I don't see it that way. There was an American toxicology report that indicated that Mr. Counsel was drug tested on April 10th, 2018. The results of that drug test indicated that there was positive results for hydromorphone and hydrocodone. However, there is also a report notation indicating that Mr. Counsel has currently prescribed medication consistent for a positive finding, and so that prescription has been verified by the laboratory, and his pubic hair was found to be negative for drug test results. And then the more recent toxicology report for June 17, 2021, as we've discussed before, there was a urine result, still contained the positive results for hydromorphone and hydrocodone, and again the notation from the lab verifying that Mr. Counsel has a prescription for these drugs. There was also the THC metabolite positive for 397 nanograms in the urine for ecstasy, which is consistent for a moderate user, and the hair results for MDMA ecstasy positive, which is an amphetamine, and the amount of 530 picograms per milligram and 755 picograms per milligram indicates a previous regular user who has stopped using for the past 2 to 2.5 months. Also, the amphetamines can be unstable in the hair. a low or a moderate level may also be due to the breakdown of the drug from higher levels. Mr. Counsel claims that he was roofied. I'm not persuaded by Mr. Counsel's argument that he was roofied. It's my understanding that the results where he claims he was blacked out or whatever it was that was his story is not consistent with the consequences of ingesting ecstasy. So I'm not persuaded by that, but Mr. Counsel is not currently seeing Gage, so I'm not going to order a full drug rehab at this time. However, if Mom would like to have request that Dad be drug tested prior to a visitation with Gage, the court is willing to enter an order for random drug tests prior to Mr. Gage seeing, Mr. Counsel seeing Gage. All right, I think that's everything except that I still need some information from Mr. Page regarding the amount of the child support obligation that we're going to order retroactive to August 2018. If you can just provide me with the basis for the amount that you would like to impose, attach the exhibits that were before the court, and give me an amount. Plus, please submit a memorandum of attorney's fees and the costs, including the cost of Ms. Norcutt's travel expenses for the evidentiary hearing.
How about the taxes?
The taxes, he's already been ordered. He's responsible for those, Goldie.
I know that he was responsible for it for like a year ago or something, like back in 2019.
There's two options. One, he can be ordered to make payments for one half of what you paid, or it can be reduced to judgment.
I guess I'm just unclear.
Your Honor, I object. It's lack of authentication. Your Honor, please.
Mr. Counsel,
I'm just clarifying. You asked for the judgment, though, didn't you?
Mr.
In one of the
Page,
orders.
if you want to talk to your client off the record,
Okay.
then why don't y'all do that? All right.
I don't want to have attorney-client problem, communication issues.
I need an order, Mr. Page. So would you please prepare the order for the court's ruling today?
I will do so.
Thank you. All right. Thank you, everybody.
Your Honor?
Yes.
Your Honor, can I talk? You've never given me the opportunity to speak. It's been like, put me on a cross and hang me.
I did.
No,
you
you didn't.
All right, well, speak.
Listen, Your Honor, I wanted to have clarification, and all you've done the entire time is address Mr. Page. I don't have an attorney, so I apologize for interrupting while you were speaking. I just waiting for my opportunity.
Well, I did give you an opportunity, and you were bringing up the thing about the college, so I thought that was all you had to say.
Okay, well,
what else is there?
No, Your Honor. There's a whole bunch, Your Honor. It's the fact that everything that has been submitted has completely gone wayside. Yes, I was roofied. I've never used those drugs previously, ever.
All right.
I've had taken a prescription.
I don't believe you. Move on. What's the next issue?
The next issue is the fact that attorney fees, we wouldn't be here if I didn't have to file all of this paperwork. And it's like everything, all the evidence that I've submitted, I understand we're not discussing custody, so I understand that doesn't take part, correct?
Right.
We dismiss all of that. Well, how am I supposed to pay attorney fees for all of that stuff when the fact that it wasn't my responsibility? I mean, the fact, Your Honor, she took my children without any knowledge of whereabouts for almost 9 months.
It's not.
And
that wasn't for a decision for me today, sir.
I understand that, but how can you sit there and justify attorney fees when that was part of the entire thing?
Because you filed the moving papers, and then after 3 days of evidentiary hearing, you withdrew your claims, sir. She had to hire.
Okay.
She hired an attorney. She paid a lot of money. She probably still owes Mr. Page a lot of money, and she incurred all the expenses for preparing for the trial, coming down here, airfare, hotel. I'm not going to award you food, by the way, ma'am. That was one of the things you requested, but I'm not awarding you food because you'd have to eat anyway. So,
Well, the factors are,
if you hadn't filed these motions, then
I have.
then we would not have had to had the first 3 days of trial, certainly, and probably not the last two.
I understand it, Your Honor. With all due respect, the factors that must be considered under the EIS for relocation 125.480, none of those were ever met. Ellison Carucci, McMonaco versus McMonaco, all of these cases I brought up to support.
But you withdrew that.
She relocated.
You withdrew that claim, sir. You withdrew
So
those
that withdraws everything. So that withdraws everything.
That withdraws all of the custody issues, and then you had the financial ones,
Okay.
and I've already discussed
Okay.
those.
Briefly, my client had to be reimbursed for
Okay.
the cost of the drug test she fronted. It's $126.
Yes, of course, that's included.
Thank you.
Will I appeal, Your Honor?
Of course you can.
Thank you.
It's your right, sir.
I appreciate that. And in all due respect, I have no idea what happened today.
Okay,
I mean, no clue.
all right,
So I apologize, but yeah,
okay.
you know, I sent you the emails. I mean, I have been harassed, mocked. That's why when you asked me about the drug test, I said yes, it's humiliating
Okay, Mr.
because
Counsel,
those are the.
sorry, we're done
All
here. Court's adjourned. Thank you.